New Beginner Study Guide, Part 2 by David Robinson. That country must be destroyed. Prior to the American Revolution, commerce was done by barter or by paper money printed by the different states according to the production of goods and services by the people. The Times of London stated the following regarding the paper money and prosperity of America. If this mischievous financial policy, which has its origins in North America, shall become indurated down to a fixture, that government will furnish its own money without cost. It will pay off debts and be without debt. It will have all the money necessary to carry on commerce. It will become prosperous without precedent in the history of the world. The brains and the wealth of all countries will go to North America. That country must be destroyed, or it will destroy every monarchy on the globe. Most people do not realize that the primary reason for the Revolutionary War was not taxation without representation, but the forced payment of taxes to the king in gold, and instead of America's paper money. America was flourishing by using its own fiat money system based off of production, instead of a gold-based money system that could be manipulated and taxed by the king. The king could not control the fiat money system, so he passed a law requiring everyone to pay taxes to the crown only in gold. The king had the most gold, the colonies had little. Scarcity equals value. Unemployment ensued and the embittered souls cried out for secession. In one sense, America won the Revolutionary War with England, but the money powers were waiting right at the gate from the start. On the surface, the British Empire as a world government lost the American Revolution, but the power structure that was behind the empire did not. The most visible aspect of the power structure in America was the East India Company, owned by the bankers of the Crown in London, England. This was a private enterprise whose flag had 13 red and white horizontal stripes with a blue rectangle in the upper left-hand corner. Betsy Ross had a pattern for her so-called creative invention of the Stars and Stripes, the flag of the international financiers. The true American flag has vertical stripes and a much different design. While the British government lost the War of 1776, the owners of the East India Company, the banks, who made up the most invisible sovereign power structure behind the British government, not only did not lose the war, but moved right in with the new American economy, hand in hand with America's most powerful landowners of the day. Constitutional supremacy, the authority for the American Constitution. 6 documents became the basis and guidelines of our American Constitution. A constitution must be based on some prior reference in order to be established. Any subsequent constitution based on this premise must have an enabling clause. No American constitution established from this point on can diminish the rights already established in the 6 documents listed below. Document 1, the Bible. 2, the Magna Carta, signed by King John in 1215. 3, the Petition of Rights, granted by King Charles I in 1628. 4, the Habeas Corpus rights, granted by King Charles in 1679. 5, the English Bill of Rights, granted by William Mary in 1689. And 6, the Articles of Confederation. Next, the people of the various states created governments for the protection of their rights. They delegated certain powers via state constitutions to the 3 branches of government that were to carry out the constitutional dictate to protect those rights. Then, the states created the United States. The American Constitution created a new structure of government that was established on a much different plane than the parliamentary system, or that of the Confederation of the States. It was a constitutional republic, belonging to the states wherein a limited amount of power was belonging to the federal government. With the remaining power delegated to the states, or remaining with the people themselves, the Constitution was designed and supported by the bankers and pushed through to enforce their control over the United States of America. Had the Articles of Confederation been improved Instead of the Constitution being devised, the bankers would have had far less control than they achieved. 10 square miles. Columbia, Christopher Columbus, the United States, all capitals, originated in 1775, not the United States of America, with a small U at the beginning of United. The Columba faction. An Italian organization and Masonic group funded by Christopher Colon and renamed him as Christopher Columbus circa 1492. The Columbus faction symbol was a black dove. The Illuminati, also an Italian organization and Masonic group, was formed in 1776. Both groups strictly adhere to their own hereditary bloodlines and purposely do not intermix with other ancestors. United States, Inc., in all capital letters, consists only of the 10-mile square of Washington, D.C., and its territories of Guam, Samoa, Mariana Islands, and Puerto Rico, etc. Plenary power. One of the powers granted to Congress in the federal Constitution is in Article 1, Section 8, Clause 16 and 17. Clause 16 says, "To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 square miles square, as may, by secession of particular states and acceptance of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and needful buildings." And 17, "to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all the new powers vested by this Constitution in the government of the United States or any department or officer thereof." Congress has absolute, or what is described as plenary power, police power, and the like. Where does Congress have such plenary power? Only within the geographical area of the District of Columbia, and all forts, magazines, arsenals, dockyards, and other needful buildings within the several states. The corporate United States, all capital letters, is an abstraction. The United States, all capital letters, exists only on paper. It is a total fiction. It exists only as an idea, whereas the various state republics of the Union exist in substance and reality. The United States takes on physical reality only after Congress activates 18 constitutionally delegated powers in accordance with Article 1, Section 7 of the Constitution. What this means is that the U.S. Constitution is bifurcated. The Constitution is separated into two distinct parts. It is separated from the original jurisdiction outlined in the Articles of Confederation. Article 1, Section 8, Clauses 16 and 17 set this out. The U.S. Congress has the right to make laws only regarding Washington, D.C. within its 10 square miles. The other territories owned by the United States, all capital letters. This limited scope of legislative powers is its only lawful authority relative to the people of the various states. The first national bank in the United States. One of the first acts that President Washington did was to declare national emergency. In 1781, Congress chartered the first national bank for a term of 20 years, to the same European bankers who were holding the Confederates' debts before the war. The bankers loaned worthless, unbacked, non-secured printed money to each other to charter this first bank. While thousands of lives were being lost fighting the Revolutionary War to get control of our own money, why did our founding fathers, Congress, contract with the same bankers that instigated the Revolutionary War in the first place? Well, it's simple. They had to. Under public international law, Congress's creditor, the Crown, forced the United States to establish a private bank to hold the security as collateral for their loans. Since the Crown, the House of Rothschild, was the creditor of the constitutionally guaranteed loans, they demanded the establishment of a private bank to hold the securities of the United States as the assets pledged to the Crown in England, to secure the debt on which the United States had defaulted. The default of the United States was planned. Throughout history, Babylon follows wherever we go. European bankers expand. "1785. The The youngest Rothschild, Nathan, expanded his wealth to £20,000 in a 15-year period by using other people's monies, an increase of 2,500%. 1787, Amschel Rothschild made the famous statement, "Let me issue and control a nation's money, and I care not who writes its laws." Thomas Jefferson stated, "If the American people ever allow the previous banks to control an issue of their own currency, first by inflation, then by deflation, the banks and corporations which grow up around them will deprive the people of all property until their children wake up homeless on the continent their fathers conquered." 1798. The five Rothschild brothers expand by opening banks in each of the major cities of Europe: Amschel, Mayer, Germany; Solomon, Vienna; Jacob, Paris; Nathan, London; Karl, and Naples. The War of 1812 and the Second National Bank. A mark, M-A-R-Q-U-E, a reprisal entitling one who has been wronged, who is unable to receive ordinary justice, to take the goods of the wrongdoer in satisfaction for the wrong. From Black's Law, 7th edition, page 986. The charter for the first private United States banks was for 20 years, until 1811. And what happened in 1812? The War of 1812. And where did England attack? England attacked Washington, D.C., the 10-square-mile district where they burned the White House and other buildings and the government records of the 13th Amendment. Was England's attack on the District of United States an act of war? No. The act of war under public international law was the District of the United States' refusal to renew the charter of the First National Bank that held the securities of the unpaid debt that the United States Congress owed to the Crown. When the District of the United States committed this act of war, not paying its lawful creditor what it owed in a peaceful manner, the only remedy open to the creditor nation under international law was to come against the debtor nation, the United States, on letters of marque, and seize the debtor nation's assets to protect its loan. Did the Second National Bank get approved? Absolutely, right after the war in 1816. When England attacked the United States because of its loan default, the Americans suffered the penalty of not renewing the charter of the National Bank. The charter for the Second National Bank of the United States was another 20 years until 1836. The forgotten 13th Amendment. Attorney. The attorney is obligated to the courts and the public wherever his duties to his client conflict with those he owes as an officer of the court in the administration of justice. The former duties must yield to the latter. Corpus Juris Secundum, 1980, Section 4. All attorneys owe their allegiance first to the Crown in England, the House of Rothschild, then to the courts, then to the public, and lastly to their clients. Is it any wonder that your attorney never wins a case for you in court? BAR, an acronym for the British Accreditation Regency. Attorneys are members of the Bar. The American Bar Association is a branch of the Bar Council, the sole bar association in England. All laws in America today are copyrighted property of the British company, the Crown. All states' codes are private commercial British-owned law. All attorneys follow instruction from England. Attorneys twist and overturn their clients in sync with the private law of the bankruptcy. That is their job. That is their pledge to those to whom they have pledged allegiance. By definition, the obligations and duties of attorneys extend to the court and public, the government, before any mere client. Clients are wards of the court, and therefore persons of unsound mind. The original 13th Amendment. One other important issue of the War of 1812. The original 13th Amendment prohibited esquire attorneys and anyone else with the title of nobility to hold any public office in America. All the states had ratified this 13th Amendment by 1812 except for Virginia. The War of 1812 was waged against mostly in Washington, D.C. The British burned all the repository buildings, attempting to destroy all records of the new United States situated in Washington, D.C. The War of 1812 partly waged to prevent the passage and enforcement of the original 13th Amendment. Many other book repositories throughout the states were burned to the ground and all records destroyed as well. As a result of the accumulated debt of waging that war and the bank-manufactured depression in the midst of the war, a new bank charter was issued in 1816 for another 20 years, until 1836. Andrew Jackson and the bank. President Andrew Jackson refused to renew the second bank's charter in 1836. Jackson's reasoning was simple. The Constitution does not delegate authority for Congress to establish a national bank. Jackson's rationale has never been seriously challenged, and the Constitution has never been amended to authorize Congress to establish a national bank, nor for that matter does the Constitution delegate authority for the United States to establish corporations. No national bank was established in America thereafter until 1913 and the Federal Reserve Bank. Andrew Jackson did an excellent job on his watch. What did Congress do to Andrew Jackson? They fought him tooth and nail, because Congress is made mostly up of attorneys who owe their title of nobility to the crown in England. Congress is populated with attorneys, who are esquire noblemen who owe their allegiance to the English crown. So who does our Congress represent? The international bankers. The bankers hired an assassin to kill Andrew Jackson using 2 pistols, but the plot failed when both pistols misfired. Andrew Jackson violated public international law in denying the creditor his just liens rights against the debtor. However, the bankers did not lend value substance, so they actually had an imperfected lien. Therefore, the law did not actually apply in this case. Andrew Jackson stated, "Controlling our currency, receiving our public money, and holding thousands of citizens in dependence would be more formidable and dangerous than the military power of any enemy." The Civil War and its aftermath. Sine die, without day, with no day being assigned, as for the resumption of a meeting or hearing. On March 27, 1861, the Southern states declared their state rights pursuant to the Constitution and walked out of Congress. This created sine die, which literally means without day, with no day being assigned to reconvene. Congress adjourned without providing a date to reconvene. Abraham Lincoln had just been elected president, and Congress could not transact business without a quorum, so the constitutional republic was gone. Therefore, Lincoln declared martial law and ruled by executive order under the War Powers Clause. Instead, martial law has arguably never been ended, and a constitutional facade has been maintained ever since then. Slavery was only window dressing for the Civil War. The war had nothing to do with slavery. It had to do with states' rights and the national debt to the bankers. The Southern states claimed their release from the debt to the crown, and as their right. The North wanted to continue its debt and its credit opportunities with the crown. When the South walked out of Congress, this ended the public side of the bifurcated Constitution as far as the Republic was concerned. What remained was the private side of the government, the military democracy under the dictated rule of the bankers. The de facto 13th Amendment was enacted at the end of the Civil War, December 18, 1865. The 14th Amendment was enacted 3 years later, on July 28, 1868. And 2 years after that, on March 30th, 1870, the 15th Amendment, Commander-in-Chief Abraham Lincoln proclaimed his first open threat to the bankers when he said, "The government should create, issue, and circulate all currency and credit needed to satisfy the spending power of the government and the buying power of the consumers." The privilege of creating and issuing money is not only the supreme prerogative of the government, but it is the government's greatest opportunity. Lincoln was assassinated a few weeks later because he defied the bankers by printing interest-free money to pay for the war. The new 13th Amendment freed the slaves from their previous owners, and the 14th Amendment subjected the freed slaves to the 10-mile square jurisdiction of Washington, D.C. instead. The only people in the United States had been under the jurisdiction of the private bifurcated government of the 10-mile square of Washington, D.C., were the government employees within the territories owned by the United States, Inc., all capital letters. Now the captive citizens of the South and the former slaves became 14th Amendment citizens of the United States. The rest of the people could still invoke their power over government through only original jurisdiction of the Republic side of the Constitution. The government operates now under the authority of private law under the dictatorship of the creditor banks. England incorporates the United States. 1871. The default loomed again at the end of the Civil War, the war against the southern states, and bankruptcy was imminent. So England incorporated the 10-mile square District United States, all capital letters. They used the U.S. Constitution as the bylaws of the District United States, all capital letters, not as authority under the U.S. Constitution, but as authority over the U.S. Constitution. They copyrighted not only their new Constitution, but also many names of the new corporation, such as United States, all capital letters, United States of America, all capital letters, US, USA, and other titles as their own. This was the final blow to the original United States Constitution. Henceforth, the United States, Inc. was governed entirely by private corporate law, dictated by the creditor banks. More bankruptcy organizations. 1909. The default loan looms once more. The U.S. government asked the Crown in England for an extension of time. This extension of time was granted for another 20 years on several conditions. One of the conditions was that the United States allow the creditors to establish a third private national bank. The basic plan for the Federal Reserve System was devised in a secret meeting on Jekyll Island, off the coast of Georgia, at the private resort of J.P. Morgan during Thanksgiving holiday day in November. It met for 10 days from November 23rd to December 3rd, 1910. 1913, the Federal Reserve Bank Act. The 16th Amendment, income tax collection for the non-federal Federal Reserve, and the 17th Amendment, public election of the senators, were the conditions for the 20-year extension of the time on the loan default. The two amendments ended the state's power and rights as the United States, all capital letters, adopted the Babylonian system of control. The ocean liner USS Lusitania, with American passengers on board, is sunk off the coast of Ireland in 1915, now seen to be a false flag event staged to bring the United States into the First World War. First World War. 1917. The United States, all capital letters, is drafted into the First World War. The debt of the United States, all capital letters, to the Crown accumulates so fast that it again becomes impossible for the federal United States to repay the debt in 1929. The war extends the war powers that Commander-in-Chief Abraham Lincoln put in place during his so-called presidency. Lincoln's War Powers Clause is expanded into the Trading with the Enemy Act of 1917, whereas citizens of the United States of America are declared to be enemies of the corporate United States, all capital letters. The Great Depression, 1929. The stock market crashes and the Great Depression begins after the financial bubble of the Roaring Twenties is burst. The stock market crash removed billions of dollars from the people to the banks. This also removed cash from circulation for the people's use. Those who still held interest in high interest yielding treasury bonds, driven even higher by increased demand. As a result, even more cash was removed from circulation of the general public, to the point where there was not enough cash left in circulation to purchase the goods and services being produced. Production came to a halt as unsold inventory overcrowded the marketplace. There were more products on the market than there was available cash to buy them. Prices plummeted and industries plunged into bankruptcy, throwing millions of people out of work and out of cash. Foreclosures on homes, factories, businesses, and farms rose to the highest level in the history of the free world. A mere dime was literally a blessing to many families now living on the street. Millions of people lost everything they had to the bankers, keeping only the clothing on their backs. 1930. The international bankers in Europe declare many nations bankrupt, including the United States, all caps. (1933) Commander-in-Chief Franklin Roosevelt takes office and issues his executive order of March 5, 1933, demanding the citizens of the United States, all capital letters, exchange all their gold for paper, Federal Reserve notes. So we the people obediently surrendered all of our gold. Why? Were we United States all cap citizens? No. We were the sovereign people at that time. We just assumed that we were required to turn in all our gold, whereas only the people living and working in the District of Columbia, Washington, D.C., and the new 14th Amendment citizens were required to do so. We were still sovereign at that time. We were not under the jurisdiction of the United States that was incorporated in England in 1871. By turning in our gold, we unknowingly volunteered into the jurisdiction of the 10-mile square District of Columbia, Washington, D.C., its laws, and the 14th Amendment. The title to our bodies, our birth certificates, were registered in the commercial registry. These titles to our bodies, representing our property and future labor, were mortgaged to the international bankers as security for the money the United States owed, the bankruptcy under the authority of the commercial title law. The American people themselves were not in bankruptcy, only the corporate United States, all caps, only the 10-mile square called Washington, D.C., not the American people. Artificial entities. How did we become subjects of the artificial corporate United States, all caps? The U.S. corporations has no more power over you than does Federal Express, unless, that is, you have voluntarily contracted with the artificial entity called the United States, all caps, in some way. Well, your mother unknowingly pledged your birth certificate to the state when you were born. It was entered into the commercial registry to register you as being within the all caps United States. This transferred the title of your body to the state via a constructive contract trust. We became members of the Babylonian system, called the District United States in every respect. Then the government created an artificial person, an artificial entity, a straw man, to represent you and to keep you in your place. Then via an adhesion contract, the government made you a fiduciary, a surety, a co-signer for your artificial straw man, to secure the national debt. By joining together in partnership with your straw man, you too became a 14th Amendment citizen of the District of the United States. All licenses and other existing contracts are made between the United States, all caps, or the state of so-and-so, all caps. And your artificial entity straw man, that fictitious entity silently binds you to the United States, all caps. Because they made you, the real woman or man, via an adhesion contract, a fiduciary responsible for your 14th Amendment citizen of the United States artificial entity straw man. All this by presumption, without your knowledge or consent, which is fraud. All the contracts you have ever signed include your tacit agreement to uphold and obey the laws, rules, and regulations passed by the Congress of the District of the United States, all capital letters, and the district state of so-and-so, all caps, in which you reside. And these contracts may be enforced in the courts by law against you. Bankruptcy trustees take possession of property. Hence, we can never own any property, because the state holds title to all. We only rent our homes that we think we own. We only have a certificate of the title to the motor vehicle we think we own, which certifies that its title is owned by the state. The state owns the true title to our homes, to our cars, and everything else that we thought or think we can own. You married the state via your marriage license, and your children are wards of the state. You are a ward of the state as well. All of this, including the fruits of your future labor, is pledged to the bankers as security against the unpayable national debt. All of this was given to the Secretary of State of each state, who is the agent of the trustee of the bankruptcy, named the Secretary of Treasury of the United States, Inc. 1935. Our pledge was further confirmed when we applied for a Social Security number via a silent contract, when the Social Security Act was signed into law in 1935. States lose sovereignty. 1933. Commander-in-Chief Franklin Roosevelt calls all the governors into Washington, D.C. for a conference of governors. This governors' conference is the beginning of the United States' loss of what sovereignty they had retained. 1944. With the Buck Act, the states become 14th Amendment citizens as well. This act ended the ability of the de facto states to protect the de jure states from being usurped by the corporate United States. The corporate states then went under the jurisdiction of the District of Columbia, United States, Washington, D.C. at the time. The march towards communism. 1946. The Bretton Woods Agreement creates the United Nations. 1964. 18 years later, the Uniform Commercial Code is adopted by all states, and a number of other like laws and acts are incorporated into this nation. The Uniform Commercial Code becomes the supreme law of the land of the United States of America. We lose our courts in 1976. Congress takes away all semblance of law within the justice system left in our court system. All law today is now construed, constructed, and made up by the judge in his or her courtroom. Congress took away any control or authority we might have had over the court system with Senate Bill 94-204. It deals with the court system. And Senate Bill 94-381 deals with public law. This has been well hidden from us all. Many go into court and often wonder why and how the courts can simply override the laws we put into our paperwork. It's quite simple. Now that we know how they do it, they construe and construct and make up what they want. A simple word such as in changed to at, as in at law or in law, has a totally different and separate meaning. For example, if you're in the river, you're wet. You can swim, etc. But if you're at the river, you might enjoy a refreshing picnic, play baseball, or run races. See the difference a simple word change can make? And attorneys often change this word when they answer your motions, and also many other words as well. It will pay you dividends to read the answers of attorneys to your paperwork. Compare what they say, case law says, to the actual case law itself. You'll discover that they have actually changed the words therein. Isn't this illegal, you might say? No, not according to the above Senate bills that permit them to construe and construct what they want. They can construe and construct any law or statute to mean whatever they decide it means, for their benefit, not for yours. You don't know any of this. You think they are railroading you to kangaroo court. No, they are legal, quote unquote, in whatever they do. They follow the letter of law, to the letter of law, their private law, the law of contracts that you know nothing about, contract law. If you don't understand the above and realize what law you are dealing with when you go into court, you will lose. Contracts. Even if you have filed your UCC1 security statement and have captured the title to your artificial entity straw man, it makes no difference in the above courts. Why? They can operate in total fiction, in the la land of Oz. They can only recognize contracts, whereas you are the real sentient being. But with numerous adhesion contracts adhere to you, whatever you file in court, whether it's your UCC1 security statement or law from the judicial and original jurisdiction side that is lawful and true, this they cannot see. They can only see the fictions of contract law. So if you go into any court, be aware that it is a court of private law, and the judge and the prosecutor can construe and construct the law in any way they choose. It will always mean that they choose it to mean because you are a ward of the court. So are the courts bound by the Constitution, by law, by statutes? No, contracts only, and the statutes that enforce contracts. And when we use their statutes, UCC rules and regulations, without a license or practice law attained from the bar, we infringe on their copyrights, for which punishment of such infringement is mandatory. There is no common law in this nation, nor in the world. There is only contract law. So the summary of this lesson. Throughout history, Babylon, commerce, and the merchant law have followed us wherever we go. The bankers were waiting in the wings when we founded this country. The bankers threw us into bankruptcy only 2 years after the Constitution was enacted. The newly founded government moved into the 10 square mile district that Congress totally controls. In 1861, the southern states walked out of Congress. This officially ended the lawful side of the Constitution. In 1871, the 10 square miles and the territories that Congress controls were incorporated in England, and the Constitution was adopted as that corporation's bylaws. This ended the United States Constitution we think of as law today. We no longer have a Constitution. We no longer have the protections of the original Constitution and the Bill of Rights, except as a masquerade to maintain the peace. The international bankers tighten their control still more. The United States, all caps, is a corporation incorporated by England in 1871 and is under the jurisdiction of England. That entitles England to create laws that the Bank of England and the international bankers dictate. And every 14th Amendment citizen is subject to obey those laws. This places the Congress of the United States above that portion of what we think of as the Constitution of these United States, not under its authority. It is copyrighted, remember? The only federal constitution left at this time are 4 amendments, the 13th, 14th, 15th, and 16th Amendments. These are all the judges are required to take cognizance and of recognize when you appear in their courts today. Then, the merchants of Babylon moved deeper into our nation by establishing the Federal Reserve Bank in 1913 and its collection arm, the IRS, to collect the interest on the loans they make to provide currency for profit corporations called the United States all caps. The 1939-29 stock market crash and the Great Depression that followed placed the American people in desperation, homelessness, poverty, and starvation. The minds of the people were focused on survival. They were trapped in a dilemma that forced them to accept any handout the government offered, no matter the cost of their freedoms. Franklin Delano Roosevelt treasonously placed this entire nation into socialism. We were drawn in as 14th Amendment citizens through the registration of our birth certificates. We were further enticed deeper into that system by volunteering for many other licenses and privileges offered by the government. You were made enemies of the United States all caps. The 14th Amendment gives the United States all caps authority over us as a captured people, under the laws of war, to force anything on us they choose to create. Therefore, we sank further into communism. This nation has fulfilled every plank of the 10 planks of the Communist Manifesto, with success. The United States, all caps, is a communist nation now. Get used to it, because it may never go away. Then in 1976, Congress removed any semblance of jurisdiction in our court system with Senate Bills 94-202 and 94-381. From this point forward, the officers of the court construe and construct the laws to mean anything they choose them to mean. As 14th Amendment citizens, we are not citizens of America that we have always thought we knew. We are citizens of England, through the corporate United States all capped. There is no law today except a fiction of copyrighted regulations and statutes interpreted by judges who construe and construct their own private law.